May I be permitted to mention the matter? Matter was mentioned last week before you lost it regarding that primary 32,000 job. And let the matter be fixed under heading to be mentioned, a date be fixed for hearing on that day upon consent of all the parties.
এই মেনশন করেছিল তো যেটা কি স্লিপটা did we accept the slip?
Mandla, it was mentioned on several occasions last week when I mentioned.
These are the matters we have mentioned together jointly also.
কেন ম্যাটার আসছে না কেন? ওরা যদি মেনশন করে
Matter is in the list. Matter is in the list.
Let the matter be taken up under heading to be mentioned so that all the parties.
you want the out of list to be mentioned. You want out of list so that the matter can be fixed and decide. This is what you want. Sorry.
My lord,
To us now I can bring my brother together. Every litigant before the court is equal. Simply because your clients have a resources and could engage such a
we don't have any resource, my lord.
persuasive lawyers, that does not mean the others who do not have those resources.
Last 2 years.
Let us see, there are many litigants who are just waiting for more than 2 years, sir.
My lord, we are only submitting
We
one
are
thing, my
trying to
lord.
get it.
One submission, kindly
We
appreciate,
are
my lord.
trying to get it. Even twice or thrice these matters were called on the last month.
No, my lord, once it was we have missed. Once we have missed.
Whatever we,
My lord,
I
the
have a- I
appellants
have a
are not
strong-
mentioned in
I
the
have a
before your
strong
lordship.
principles in this regard. Every litigant, definitely
My lord,
they get the
correction, my
equal.
lord.
They
Kindly
should get
visualize, my
equal.
lord.
No.
3 years, my lord. Everything is complete.
Sir,
Motion
we
arguments
are here
advised,
for
my
a
lord.
pretty small time, this determination. We are trying to get it
But they are
everywhere.
suffering, my lord. Kindly visualize, my lord.
Everybody is suffering, sir.
This was clear
See,
direction
it's
passed
simply
by the
because
Honorable Supreme Court,
they
my lord.
could engage Mr. Tiwari. That does not mean that the other litigants would suffer for that.
Matter went up to
No, it is-
Supreme Court. Requested the High Court to take up the matter on.
We will take up, we have taken up, we called, nobody last week.
My lord, it was because last 2 months back, my lord. 2 months back, we have missed. We have also.
Determination is just now given to us.
And my lord, only one submission, my lord. The appellants are never been mentioned before your lordship. We are the aggrieved party. We have filed application, my lord. They are enjoying them.
We will record. These are all under the hearing matter.
Yes, my lord.
Fix 1 day for hearing. Come ready on that. Every week we will keep 1 day for hearing. Don't worry.
My lord, we are only appealing you, if your lordship, if possible, my lord, some privilege may kindly be given. No, not for that reason, not for any special, my lord. We are suffering because they are enjoying their benefits. We are the genuine candidates, my lord, those who could have get the job. But they have enjoying it in the interim order, and they will not mention.
Interim order, we have to see to it.
They are the appellants, those who are before in service.
It will come as an application. We'll take up the application.
Application, the heading in the application.
The application was entirely called on the 6th.
Yes, once we have, it was called, my lord. After that, we have mentioned. My lord already told us. My lord,
Rise early
My
after
lord, no.
calling the
my lord already told us, my lord.
My lord, this matter was taken up once, admittedly.
No, sir.
At 4:20.
No, sir.
And
No.
the appellant was not even there, my lord.
Whatever. We will dismiss on the next day if they do not.
My lord, the suffering, kindly visualize.
We
what is the
consider
matter.
it. Yes.
My lord, this is an assigned matter. My lord, item number 3.
We'll take up for
My-
hearing matter.
My lord, for inclusion.
Applications of.
My lord, for inclusion.
Please, applications,
My-
please give.
Application.
Please give. Applications
application.
give.
Order for you.
Please give the applications.
Application.
We'll see to it.
My lord, hearing.
No hearing.
My lord,
We will fix the Thursday for hearing. Don't worry. This Thursday will take up. Don't worry. Let us dispose of some. Application, I said, let's give. Don't mention the matter.
Lordship, with your kindly would like to mention that Union of India was Electro Steel matter. Your Lordship had indicated that last week it would come for judgment on Friday.
Come for judgment. Don't worry. Why you can't put a pressure on the judge.
No, your Lordship
You
had only
may
indicated.
have, but we have lot of matters. So we have to do it. And at least we are entitled to some gasping period to go and ponder upon.
Absolutely, Lordship. Your Lordship had only indicated, that is why I was only.
Sorry.
Your Lordship, with your kind leave, may I be permitted to mention this is for extension of interim order. Your Lord, briefly.
Your Lordship's kind leave to mention a disposed of appeal, my lord. I'm praying for one indulgence. My lord, on the date of disposal of the appeal, my lord, your Lordships were pleased to direct the learned trial court to dispose of the injunction application within 1 week, which is between from 21st to 28th. My lord, I'm led by Mr. Suman Dutt, learned senior counsel, but he has some difficulty praying for except 2 days' time. My lord. If it could be disposed of by 30th January, my lord, I'm grateful.
I just appeal the certified copy of
Order dated
8 January.
certified copy applied. Have you annexed the photocopy? Annex.
Then I
And the server copy. Annex,
Permitted.
annex that photocopy of the application for certified copy.
Madam, may I be permitted to mention one application? Madam?
No need to mention, please give, pass on. Just wait for a time. Wait.
First time we're hearing, but
Wait,
I come after some.
after some time. After some time. We'll see to it. Yes.
My lord, with the leave of justice Proceedings recess, I beg to submit more.
No, you mentioned the matter. The file was sent to us. It was a single bench matter.
Yes.
It is not with me. It's not an assigned matter.
This is not an assignment.
Correct. It's not an assigned matter. So you'll have to go before the regular bench taking up this determination.
But I have got the letter from the
No,
Supreme High Court.
cannot be done
Yes,
for
sir.
us.
Because as a bunch of contempt petitions with the writ petition, already one contempt petition is disposed by your table.
Maybe, sir, but the Chief Justice is the master of the roster. We may be allotted a roster at that point of time. We took up the matter. Now there is no roster. We have not been given a roster. So you'll have to go before the regular bench.
My lord, the bunch is present here in this.
We called because you mentioned the matter. So we called the file. We perused the file. And find that when I was sitting singly, having a determination, I passed certain orders. But
Then you have
thereafter-
already released this matter,
no, it's not a release matter.
already assigned before you.
No, not assigned matter. That is what I'm saying.
My lord, again
It's
I'm
a-
appearing the next day because I'm definite because you appointed one
I
lawyer
have seen
also for
a
me.
file টাকে দেখিয়ে দাও, perusal করে দাও. There is no order of assignment which is passed by the Honorable Chief Justice. You go consult the file, please. There is no order of assignment.
My lord, how you have come to know? I have appeared so many times, 15 times. I appeared before you.
True, but I did not find the order of assignment with
But
me.
that is not my fault, my lord.
Sir,
I'm
that-
waiting for 90.
but
80.
our power emanates from the determination. We can't take up each and every. As per the roster, not an assigned, as per roster. Means whoever is getting a roster, he will take up.
Then what will be my, at this moment, after 8 years, what I will do? Already I have retired, waiting that my lord,
we
Justice Tendon will see my case.
we appreciate all the agony, but the problem is that if we take up the matter without any roster, it will create an anomalous situation. It will be a chaotic situation. That's why the Chief Justice allots the roster. That you will
The
take up
roster means the subject matter. But you are selected for the service matter for me.
No.
That changes.
No, that is what I'm saying.
Then what to approach?
Roster.
The roster means I prayed before the justice.
Single bench, the service matters are assigned.
Then again 30 years. I'm waiting for 30 years, my lord.
I have no answer to this query. But the problem is the court functions with certain procedures. If the procedures are creating, I am also with you that sometimes the procedure creates a problem, but one has to embrace it, one has to accept it. Because without any procedure, there will not be, this will be unruly horse.
Okay, my lord, the last case, which was disposed by your hand, I'm going to search this matter.
Sorry.
Because that time, that was the assigned matter, the total branch.
It was only for a specific, because I had the determination, that's why those.
No, that time you were not in service matter, my lord.
You just go
please,
through it. I have seen. Please. ওনাকে বসিয়ে একবার দেখিয়ে দাও record. Yes. Call them.
স্যার হুজুর আমি দু একটা কথা বলতে চাই, আমি অ্যাডভোকেট নই,
আমি একটু এসেছি আপনার সঙ্গে কথা বলার জন্য।
কেন এটা কোর্ট ইস কথা বলার জন্য
আমি
জায়গা
একটু
নেই?
বলছি স্যার, আমার একটা
আপনার কোনো গ্রিভান্স
হ্যাঁ
আছে?
গ্রিভেন্স আমার একটা মামলা আছে
আমাদের
বলছি
এখানে
স্যার,
না অন্য জায়গায়?
এই ঘরে
কি?
FA 271 2014,
হ্যাঁ,
FA 332 of 2016,
হ্যাঁ,
অ্যাসাইনমেন্ট নম্বর হচ্ছে 2019 219 220।
হ্যাঁ।
এটা হচ্ছে স্যার অনেক দিন ধরে এটা মামলাটা আমার এখানে পড়ে আছে এবং আমার উকিল সাহেব এরা অনেক চেষ্টা করেছিলেন। সেই করোনার আগে একবার এটা হয়েছিল, তারপরে আর কোনো রকম এটার উচ্চবাচ্য হয়নি এবং
উচ্চবাচ্য
ওরা
অনেকবার
ডেট
পুরো
নিয়েছে। এবার স্যার
পুরো
আমি
লিস্টটা
বলছি,
কল
আমি স্যার
হয়েছিল,
একটা সিনিয়র
কেউ কিন্তু
সিটিজেন,
দাঁড়ায়নি।
আমি আমাকে একটু বলতে দিন প্লিজ। আমি সিনিয়র সিটিজেন লোক,
আমিও হয়েছি।
70 ইয়ার্স ওল্ড। আমি হচ্ছি আমার হচ্ছে মানে নেই প্রবলেম, আমি
স্যার,
ফিজিক্যাল
স্যার,
হ্যান্ডিক্যাপ, আমি বলছি
আপনি
স্যার
আগেও
প্লিজ।
শুনেছেন, আমি বলে দিই আপনাকে, দেখুন প্রত্যেক লিটিগেন্ট যারা কোর্টে আসে তাদের সামান্য মানে সেম রাইট থাকে, তাদের সবারই
একটু বলে
equal
দিন।
right।
আমি একটু
এখন
এই জন্য এসেছি।
আপনার এই মামলাগুলো কল হয়েছিল গত মাসে, সব পুরো লিস্টটা কল হয়েছিল। যেহেতু আপনারা রেসপন্ড করেননি, ডিসমিস করিনি মামলাটা, এইটুকু বলতে পারি।
আমি এইটুকু খালি
কেন
বলছি
তাতে
স্যার,
আমরা মনে করি যে লিটিগেন্ট সাফার করে লয়ারের
স্যার আমার একটা রিকোয়েস্ট আছে যে আমার
এটা
মেয়ে,
হবে থার্সডে হিয়ারিং
স্যার
ম্যাটার
আমার মেয়ে, স্যার আমি বলছি স্যার
হবে।
একটুখানি স্যার, আমার মেয়ে স্যার ক্যান্সারে আক্রান্ত এবং আমি সেই ট্রিটমেন্ট আমার আটকে গেছে এই কেস করে। এবং এই প্রেসক্রিপশন আমি টাকা দিতে পারছি না এবং এবার আপনি যদি আমার উপর একটু দয়া করেন তো আমার মেয়েটা বেঁচে যাবে স্যার।
ম্যাটারে কোথায় টাকা নিয়ে কি গল্প আছে?
না না, আমাকে তো এখানে তো টাকা অ্যাডভোকেটদের দিতে হয় এবং সেজন্য আমি স্যার সব রুখে গেছে।
ওটা আমি লিগ্যাল এড থেকে যদি
Please,
আপনি
স্যার, এটা
মনে
একটু
করেন
দেখে নিন,
লিগ্যাল এড
please, স্যার,
থেকে
আমি-
আপনাকে একটা লয়ারটা
একটু দিন না,
করে
স্যার,
দেওয়া যাবে,
স্যার,
অসুবিধা
এটা একটু
কিছু
দেখে
নেই।
নিন, please।
লিগ্যাল এড থেকে আপনি একটা লয়ার নিতে পারেন, আপনি অ্যাপ্লিকেশন করুন।
স্যার এইটা
হাইকোর্টে-
যদি আপনি একটু শেষ করে দেন তাহলে আমি এটা খুব উপকৃত হব স্যার,
আপনার
আমার
লয়ার
মেয়েটা বেঁচে যাবে
আপনার
স্যার।
লয়ার কোথায় যাকে আপনি এনগেজ করেছেন?
ওই আমার লয়ারকে আমি বলেছি, ওরা চেষ্টা করেছিল, তারপরে
আপনার লয়ার তো এখনো রয়েছে।
হ্যাঁ
আপনার লয়ার কোথায়? ওনাকে একবার ডেকে নিয়ে আসুন আমাদের সামনে।
স্যার এটা একটু দেখে নিন প্লিজ
আপনি লয়ারকে ডেকে
আমি
একবার
ডেকে
ওনাকে
নিচ্ছি।
রিকোয়েস্ট করুন আমাদের কাছে যেন 12টার সময় আসুন।
স্যার এটা একটু
এটা আপনি রাখুন আপনার কাছে, ওনাকে দিয়েই নিয়ে আসুন,
ওনাকে
উনি
দিয়ে
দেবেন
দিতে
আমাকে।
অ্যাডভোকেট। আচ্ছা স্যার, আচ্ছা স্যার 12টার সময়
Lordship, this is a matter for correction. Lordship had disposed the matter on 12th of December. So what happens, Lordship, we had appeared for the respondent, but the order mentions that we have appeared for the appellant.
নন্দী ছাড়া তো আর কিছু হতে পারে না, মানে দিস ইজ only one officer who does that. নামগুলো সব অ্যাপেলেন্ট করে দিয়েছো, রেসপন্ডেন্ট কোথায়? অর্ডারটা কি হয়েছে দেখি, অ্যাপেলেন্ট অ্যাপিয়ার করেছে
The respondent Shomita Das.
Please give the corrected names. এই ওখানে কেন করছো? সই করার অর্ডার?
But I've laid by Mr. Mitra.
Led by Mr.
Mitra. পিছনে
কাগজপত্র নাই তো দিয়ে দাও কাগজপত্র। I don't know what the problem. রাখুন না।
হয়েছে
And there's one difficulty. And as far the paper book is concerned, we have indicated them. There are some missing papers. We have already forwarded the same to them. Therefore, these are the papers which are missing from the instant paper.
Have you got the copy?
I've already indicated them. From that we have searched.
I
And
suggested that if there is any paper missing, you think
You prepare a supplementary paper book so we can have the matter heard. The
Until
papers
unless
which
the
my
lordship gives the
lordship
direction.
No, no, I don't think it is necessary.
You should have come with the supplementary and then ask for a leave. We will grant
Yes.
No, I've already indicated that. These are the papers which are missing at
And
this.
we feel that these are not the necessary papers.
No, no,
But if you think that necessary, you file it. I am not standing in the way.
when you indicated.
Yes, on
9 January.
9 Jan.
Why don't you, where is your, why don't you do it?
Well, kindly see the documents. They are not necessary. They are not application papers. Now the appeal is being heard.
Once it's a paper book, it has to be complied with everything. And can I kindly note what
No.
affidavit and reply on our part is missing
Of what, main matter or?
of the main matter.
Reply has not been filed.
Kindly have a look.
If reply is not there, this is an
Reply,
important.
reply is our reply.
They are
Not
reply.
the petitioner.
Reply.
And supplementary to Samadi.
So reply is there.
He is there.
No. Affidavit reply to the affidavit in opposition
Yes.
first, and there are two. There are 2-3 affidavits. If I can.
I understand. One reply to the opposition filed by the respondent number 123. Reply to an opposition filed by the respondent number 11. These are the two.
These are the applications which have been disposed of long ago. This is the,
Kindly have a look. What we have sought for. These papers are missing from the main file. For thus we have relied on the basis of that. The order was passed.
I don't know.
If I don't get the papers from the paper book, it will be difficult for me to argue.
You rely upon those documents.
December
No difficulty.
2023.
You rely
And
upon those documents.
if you think that necessary, you can easily file a supplementary paper book. Well, I shall definitely accept. We thought that these are not necessary. If you think they are necessary, with the leave of your lordship, the matter.
Yes, that is the system. Until and unless the leave.
No. You can rely upon these. After all, the High Court is a court of record.
Yes, until and unless lordship grants me the leave after the paper book, can I come with until and unless there's the order of the court? I put a question to myself.
Freehand, already done. Many a times we learn from those seniors. Get it ready. Keep it in your hand and ask for a leave so that the court will permit you to file.
Everywhere we don't get the facilities. Lordship knows I cannot be more specific.
I still believe in the old.
I restrict myself.
I still believe in old courts.
Yes, I believe, and I'm everywhere. Code number 8 is not available. Lordship knows.
May I suggest this just to cut short
But there is a difficulty. I was noticing page 86.
Oh, I see.
You come
Those papers.
of the paper book. Please look at it, Mr. Mitra. How can we function?
No.
Come to page
No,
86.
these
Please
are my
come to page
yes,
86.
page
86.
A.
Sorry, I will take you to 86A. 86, please come.
Yes.
Mr. Mitra, have you got 86?
Yes.
Can you read a single line? No. Then come to 86A. Illegible. What?
No translation.
Now tell us that what to do. This is a typed copy. Typed copy, illegible. Illegible. 86A.
You will have to get into the original document.
And say typed copy. What is this typed copy you say?
Typed copy is illegible. Which is a very truthful typed copy. I must frankly confess, a very truthful fact.
Look at 86A. I said I will. I will.
Well, and this, I tell you, Lordship, this is a letter by the University of North Bengal. My learned friend is appearing for them. But if the
This is a letter from University of North Bengal.
yes. So this letter, my lord, I don't know. I shall try and find out if the original is there, which I can read. This is written to a third party, not to my client. Then, my lord, I could have got this. But may I suggest this with the greatest of respect? Well, the matter is to be heard sometime or the other. If my learned friend thinks that there are some papers which are not available before your lordship in the paper book.
What is the point? Let me see.
The point is very simple.
Yeah.
It's a short point. My client, who is already working as an assistant professor in another university, he applied to the North Bengal University for the post of assistant professor in Bengali. Now there is a procedure. There was a written test, there's an interview, all these things took place in terms of University Grants Commission regulation. Our grievance is this, that the University Grants Commission has laid down certain provisions with regard to the acceptance of a particular candidate. There are certain guidelines.
Eligibility or what?
Eligibility criteria has been laid down. Our grievance is this, that even though I satisfied the eligibility criteria, and a person who is a very, what should I say, erudite person in Bengali, having stood first class first in MA in Bengali, gold medalist, etc., he was not called in the interview. My lord, in the interview, they were not called, even though, my lord, that score sheet which has been disclosed by the university shows that I am a person who should have been called in the interview in preference to the person who was ultimately selected. So that is the grievance with which I came before the court.
What is the criteria? The merit is definitely a criteria.
Yes, of course. The marks. I tell you, Lordship, where the difference is. One of the criteria is good academic record. What they have done is they have taken the higher secondary, graduation, postgraduate, and they have taken a certain mark. He said that you have to qualify according to this. Our submission had been that when your lordship takes into account the total mark that they have computed, my mark is higher than the person who had been accepted. So I submitted, our submission was, why should I not be called for interview? Because my mark is more than that. I can show to your lordship immediately.
Why they have, what is their step?
Their contention is this, that you did not get as much mark as you should have in the school final, or my lord, the higher secondary and undergraduate. I say that it's a professor, assistant professor in Bengali. Therefore, should you have taken into consideration my marks? After all, my proficiency in Bengali you will have to look into. A person who is a professor in English.
Criteria that for higher secondary marks, this much marks will be allotted.
No, there is no such thing.
There is no
such thing.
It says the good academic record.
Good academic.
And everybody will have to be marked or given a marks.
Yes.
On the basis thereof.
Yes.
And it appears that overall marks, the total marks is higher than what.
Yes, because two things. I got my marks in my lord, the postgraduate in MA was much higher than anybody else. Number one. Number two, I'm a doctorate in Bengali. And my total mark is more than the total mark of the person who was called in.
Called for an interview.
Yes, called for interview. My grievance is that. I said that when you are taking a person,
why the voluminous documents are required?
The voluminous documents are not there. My submission, I will not take more.
Except we have to see the advertisement notice.
Yes.
We have to see the UGC norms, which provides how the marking has
My
been
lord.
done. And then the
Your
disclosure which is made by them.
I shall rely upon their marks.
That's all.
The marks, that's exactly what my submission had been.
Then why we will go into so much of voluminous?
No, your lordship.
Why the single bench?
Two things, well, I tell you, lordship, two things your lordship needs to look into. Number one, my lord, University Grants Commission regulation. Number one. That's the first thing.
4 things.
Not even 4 things. And second thing, the mark that they have given.
First thing is an advertisement.
Yeah.
By the advertisement, they must have disclosed certain criteria.
University Grants Commission, the same as.
Second one is the UGC norms, whether it is in conformity with.
Yes.
And the third one is the total number of marks obtained by all the candidates.
And for that, I'm relying upon their records.
This is the main 3 documents one has to look
That's
into.
all. So
why single bench rejected your prayer?
Well, the learned judge said that in the learned trial court had said that good academic record means that you must be doing very good in
consistently.
Yeah, consistently. To that, my lord,
But for that, the marks have been allotted.
the marks have been allotted.
Say the 15 marks for good academic.
Yes.
So you may be awarded more marks.
No,
you
may,
be
may I
awarded
tell
14
you,
marks,
Lordship?
But ultimately, total marks.
Yes, my lord, that is the point. I got less mark in higher secondary than my learned friends, the person who was selected. I'm less mark in undergraduate than what my learned friend client got.
But you got the better marks.
Better marks in MA, and I am a PhD. And my academic.
Was there any criteria for
Yes,
PhD?
for PhD.
Preference
Oh,
or,
yes.
Or any kind?
Yes, and according to their own calculation, my total mark is more than anybody else's.
That is what I am asking.
That is exactly the. And so I said there is no there was
You
no.
were not called for interview also.
No, I was not called for interview. I should have been called for interview. But I just this is the submission I made before the learned judge, that if you asked, when I took this name, Professor Tarok Sen in English or Professor Subodh Sengupta in English, how much mark you got in school final or matriculation examination, would that have been fair? A professor in English, how much he got in mathematics, will that be a proper criterion to decide as to whether he should be called for interview or not? No, my point was very simple. That was the only point that I made. Well, Lord, I was just asking this question to myself. Your Lordship has been pleased to, I don't know whether Professor Gauri Shastri, who was the principal of Sanskrit College, how much mark he got in English or in physics or in mathematics, and that should be the criterion for the selection as the professor of in Sanskrit in an university. Would that be fair? I asked this question, my lord, to myself. I put that question before the court
only
also.
thing is the subject in which whether you have got an expertise, proficiency, you have got some kind of a.
Absolutely, my lord.
What is
That
very
was
important.
that's what that was my submission. Your Lordship will
Then
please.
why it was repealed? That says no. Consistent academic records.
Consistent
And what
academic.
about the total marks?
My lord, will your Lordship kindly come to page 182? Straight away, I go straight to the. This is, my lord, what they had given the marks.
No, I understand. I appreciate. I'm just talking about where is the finding of the single bench in this regard? Why it has rejected?
That was consistent good mark. Your Lordship
Where
takes
is
this. Well, this will be made it clear. Kindly come to page 182.
Yes.
My lord, she, the number 1, was the one who was selected.
Yes.
High secondary, 67.8. Undergraduate, 56.12. Postgraduate, 60. Average ABCD is equal to 61.3. Total score, 15.3. Net set, 8. PhD, 0. Research performance, 4. 27.3. Now, my lord, kindly take, my lord, my mark. Lordship, will you please to come to serial number 18 at page 183. Purimal Chandra Das. I got poor mark in higher secondary, 46.2. Undergraduate, not so bad, 50.37. Postgraduate, 60.2. My average became of these three, 52.3. But, and total score, 13.1. As against, my lord, your lordship is to see 15 of, my lord, the first, 15.3 of item number 1. Then, my lord, kindly see, net slate, 8, PhD, 7. Whereas 0, insofar as 1 is concerned. Then research performance, 8. I got 36.1. As against, my lord,
27.3.
27.3. She had been called, I have not been called. I said,
one thing you also notice.
your lordship.
So, the first candidate, there was a decline in the higher study. And in your, there was an upward tendency in the higher study. Why? Higher secondary, she got 67% marks.
Must have scored very good in
Undergraduate, she
mathematics.
got 56, so decline. And in PhD, got 60, decline to higher secondary. But yours, 46, 50, 60, means there was always in an ascending order. So a person is really performing or doing good
Yes.
in every sphere of the life.
And kindly see research performance.
That I see
She
8
got-
and 4.
She
8
got
and
4 and I got 8.
8 and 4, I have seen.
Yes. And in addition, I have got PhD. I am a gold medalist in Bengali. Try me out. Call me in interview. Maybe I'm a stuttering person who can't speak. If you think that way, you reject me in interview. But why should you not call me in interview? I am asking that.
Sir, I just wanted to know the findings. Sir. Why the single bench?
Your Lordship will take that. Lordship will please to take, my lord.
It's 206 is the order.
Yes.
Just give us 5 minutes
Yes,
time to go through it.
Lordship. Page 213, the finding.
I think the entire case is rested upon the Supreme Court judgment of 2008, Volume 1, SCC, page 362.
Yes. This is with regard to shortlisting. I am not questioning that. I am not saying that you can't do shortlisting. Of course, you will have to do. If there are 10,000 candidates, shortlisting is absolutely necessary. But how do you do it? The criteria has been laid down. Can you deviate from that? That is my contention. Shortlisting had not been questioned by me. Two things, my lord, I wanted to submit to your lordship. My lord, kindly take this decision once. I say, my lord, that there is perhaps the learned judge has really gone wrong in, my lord, bending backwards. In kindly come to page 213, the finding of the learned judge.
There is one striking distinction which I noticed.
Lordship.
A particular word is added,
Consistently.
which is not there.
I have marked it in red. It is not there. And my lord, your lordship will be good academic. And this concept of good academic record, your lordship will be surprised to know that this is 2016, or rather 2010, University Grants Commission, my lord, the rules have been relied upon. In 2018, when this particular interview took place, there was a significant, my lord, change in the criteria. Good academic record had been omitted. It is only how much mark you have got in MA. Lordship will kindly take this.
No, that's true. But once the initiation is done under the earlier one, that it has to be followed. I noticed this. I have already given a circled mark there.
And my lord, kindly see another page. I am relying upon university records. I am not deviating from that. Kindly come to page 67.
Now what to do now?
Well, this particular...
Now, 2018, I noticed another striking feature here.
Lordship.
That you really approach the court in a timely manner.
Absolutely, immediately. Well, I am very grateful to your lordship.
And then during the pendency, they issued the appointment.
Absolutely.
And that really prompted you to bring that appointee as a party there. So you can't be blamed for that you were really sitting on a fence or something of that kind.
Unfortunate
Now,
thing is this 2018
It
matter
took
was
so
heard in
much of time to
2024.
dispose of. Now, today we are in 25. What to do now?
Well, the university can do one of two things. I don't know what is the strength now of the academic staff strength. But my lord, they will be able to tell you, lordship, if there is a vacancy. If there is no vacancy, why should I not be given some kind of a supernumerary post for the purpose of being inducted? After all,
recently the Supreme Court has deprecated this creation of a supernumerary post.
Well, otherwise, this is something, my lord,
I understand.
well, we lawyers will have to account for this kind of situation to our clients. The client is saying that, look, immediately after the thing took place, I came to court. 2018, 3 opportunities were given to my learned friend's client to file affidavit. They filed one affidavit by the then registrar, second affidavit by another registrar, my lord, officiating registrar, subsequently, and the third one also was filed. And the records were brought time, my lord, time from time. And my lord, there was an interim order that no appointment shall be given.
Then how the appointment came?
The appointment was given.
In defiance of an interim order.
Of
And why you did not take steps?
Yes, we filed a contempt order. Honorable Court said that I shall decide the matter immediately. Justice Sin at that time.
Well, my learned friend will be able to say, I was not in the contempt matter.
What happened to the contempt?
My lord said that don't worry about contempt. I will hear the matter. It was fixed for hearing.
No, I understand. Then what happened to the contempt?
Contempt was there, but it was not proceeding.
Proceeding is still pending.
It is still pending.
Still pending.
Well, this is an additional point, my lord, which I did not know. I must frankly confess to your lordship, I went on to the merit of the controversy. In an appointment made contrary to order of court is a void order.
Who was the interim order?
Interim order.
I included it here. We'll hear you. Let me first ascertain the
I
fact.
don't think Lordship need to get on all these things because interim order which was there stood modified, preferred a contempt was thrashed. There was no. That is the reason why I was expediting the issues.
I don't know really.
Mr. Mitra was not there. Even I was not there. Subsequently, we came to know.
এটা দেখো বলছি ঠিক সালের অ্যাপ্লিকেশন 2024 সালে হিয়ারিং হলো কি বলবে তুমি বলো
এই অর্ডারের সম্পর্কে ছিল বলে
তারপরে আমাদের শুনতে হয় from others যে
You are representing the successful candidate.
No, he is the representative. I am for the university. I have in the paper book and in the I have not brought it, but it was there.
He says something differently.
He was not there.
No, he says that this interim order was subsequently modified. The contempt application which was there has been thrashed.
That's what
Modified to the extent that all
But
the
you did not say to your senior, not to us, that this interim order was modified. You simply told your senior and who percolated it that there was an interim order. In violation of the interim order, the appointment was done. Contempt was made, contempt application. The learned judge says, hearing, I will dispose of. Don't worry about contempt.
Then, my lord, no, interim order was there. When, my lord, this at that time, Dr. Patru was there. He said that we are not giving the appointment. Then, my lord, Mr. Sichina said that all appointments will abide by the result of the writ petition.
Did you not say that to the senior?
Because these are all.
Will you not say it to the senior? You projected the fact in such a position that even a senior or a bench will get that how it can be done on the teeth of an interim order appointment. How can that be said to be a legal one?
When the appointments were made, there was interim order.
So you did not say to it Say to him,
At the trial court stage.
why you did not say that it was subject to the result of this writ?
No. Subsequently, it was modified. All appointments will abide with the result of the writ. When Dr. Patro said that we are not giving any appointment, but subsequently.
Then how the appointment came? So it will be that he was seeking a leave, that we can't run the institution without any teacher
that leave
or a
was not
professor.
sought.
Please permit us to appoint. The court must have said that yes, appointment
is nothing.
subject to the result of the writ petition.
As my lord, appointments are given, we find a contempt application, we insisted for hearing contempt application. Then they said, we have taken steps and we will not give appointment. But when it was on record, we brought to the notice, appointments have been made. Then my lord, it was said that appointments will abide by the result of the writ petition.
Well, this is very serious thing. This, if necessary, I shall have to put this. Do not know what will be the interpretation of these orders which have been passed.
Definitely not. A thing done on the teeth of an order of injunction. What we learned is that these can't be said to be a legal one.
No, it's a void order.
The void, illegal.
Well, this gives a new angle. I did not argue. I must frankly confess to your lordship, I did not argue this point because I did not.
Apprised of that fact.
Okay, I did not know. I did not know that all these things have transpired. I proceeded purely on the basis of the record.
No, this point
produced by
was
the
raised.
university.
This point was raised, subsequently found that interim order has already been stood out to be
Does not appear.
reflects from the order itself. Be that as it may, since it's already been done way back prior to the.
Can't say that it was argued. Mr. Mitro, who was there before the single bench, he knows what he argues.
No, I did not argue this. I am sure my
No, I'm not onto that.
No.
But
Why you
this
say
point
it
was taken,
taken,
and
argued?
since the issue was already given a go by subsequent to the modification of the order, then nothing remains to be heard on that issue.
No,
A particular order which stood modified.
not so easy, Mr.
Not so easy.
Not so easy. Not so easy.
No, if an order is being passed on the very day appointment is being made, subsequently they come up, no, already appointments have been made, therefore this order cannot be given in implementation. Then what would be the order of the court? Order obviously will abide by the result. That is the reason why the parent order stood modified.
Obviously, sir. Chosen a wrong civil judge.
That's what he would.
There are catena of judgments of the Supreme Court that if any act or a thing is done on the teeth of an order of injunction,
Yes.
then it is not only illegal but void. What he says is correct.
Grateful. I bow down. But if it is being done, here I stand.
My lord, I should brought the record. I put another application.
That is also missing.
Here, my lord, I have stated on November 14, 2018, Honorable Justice Arindam was pleased to pass a
এটা কোথায় রে? আমাদের paper এটা।
order dated September is modified to that the appointments in subject sociology, Bengali history are not to be given effect till disposal of the writ petition. I can produce and I stated. Then all the orders are passed in present learned advocate in the university.
No, there are two things. There are two situations. Mr. Counsel, please consider. One is that an appointment already made before the interim order is passed. And it is a different thing that an appointment is made after the interim order is passed. There are two concepts. In a first concept, the court sometimes says that now since the appointment has come, there was no fetter, it will abide by the result of the writ. It normally passes the order, usual order. But in the second situation, it is a serious one. It touches upon the majesty, sanctity of the court and its order, which is more serious in nature.
That's why, my lord, then, my lord, that the orders are passed in presence, then university also defied the interim order and made illegal appointments in 3 subjects, history, Bengali and sociology and also other.
That is your contention.
No, then the applicants filed contempt application, but the same was disposed of the Honorable Justice with observe the main matter should be heard and decided.
This is what my learned friend is also saying.
But he did not say to you this facts.
At even at trial stage, the writ petition is pending despite a best efforts due to COVID pandemic. It could not be heard and decided. Then, my lord, appointment.
So the contempt application was disposed of
Yes.
by directing that the matter should be heard. So, my lord, in all fairness to my learned friend, perhaps one can say that the contempt application was disposed of on these terms. So, my lord, whatever it is subject to the result of that.
So, Mr. Vikram, would have appreciated if your immediate instructing lawyer instructed you properly. We appreciate it.
No, but I should have told you a lot.
Attempt does not mean that mere violation will expose the person to liable to be punished. It should be willful, deliberate, knowing fully well that there is a restraint, yet he in present, I would say, present defiance of an order he has done so.
Lordship.
So that is the element one has to see. If it is the innocent by mistake or something is done, then he can't be guilty for contempt. I appreciate. But the order appointing him, that has to be tested.
Right.
Whether that is legal or that is not.
That is the point.
Tested.
Well, really, I am on that. I am not.
I appreciate. Since it was dismissed, so there was no question of going into that aspect.
Yeah, that aspect.
If the order is reversed, then we'll have to think about that. What would happen to that appointment? But he should be very correct.
No, my
I'm
lord,
not
then-
using the word another. I'm not saying.
No, then what happened? After end of COVID, my lord, we filed this application for appropriate order with the statements that mentioned now application of this Sogata Bhattacharya. Then there was initial illegality, there were subsequent developments after filing writ petition. That the illegal appointments have been made undeserving and lesser qualified candidates.
That is something on merit. That is something.
Then another statement. University, knowing fully well that Dilip Kumar Sarkar is the registrar of university, North Bengal, allowed him to be involved in the selection process, though his daughter likely was an applicant. Then these are my lord. Then
On the merit.
Then this application was at the trial station that when we are hearing the remain repetition.
Let us hear the university what he says.
But only one other page I wanted to show to your lordship. Page 67. The university record. 67. Well, the page that I showed to your lordship now, the earlier, that is one of the second registrar who filed a second affidavit. Now the first registrar who filed the first affidavit, he, my lord, annexed this with his affidavit, my lord, at page 67.
Yes, that's the chart.
Yes, again chart, and there is it's easier comparative chart of the lady who was appointed and my client. This is also important. Post applied for Assistant Professor Bengali OBC-B, Porimal, Assistant Professor OBC-B, subject Bengali. Academic record 15.3, your lordship saw that in that the bigger chart at page 193.
Oh, I got it. Yes, and it's 13.1.
13.1.
Right.
But then my total academic
Total is 27.3 and 36.1.
I should be
You got 36.1.
Yes.
So higher than them, but still you are thrown
I
out.
was not called for interview. No, before that. Kindly, my lord, see the bottom. This is something which I've argued very vociferously. Though the candidate serial number 2 scored 36.1 in academic and record and research performance, he was not shortlisted as he failed to achieve 57% marks in average, taking higher secondary, undergraduate and postgraduate as decided by the screening committee. What did they get this 57% from?
There must be some decision which is taken.
What? How can screening subcommittee take a decision contrary to the UGC eligibility criteria? 57.5 for the purpose of, my lord, excluding me. You have fixed this. This is my question. Kindly see, my lord, the remarks on the extreme right hand column. Very interesting. These are university records I am relying upon. Kindly see. Appointed and joined on 13/9/2018. এটা কি যখন interim order ছিল না on 13
order was passed.
ছিল তখন interim order ছিল।
Where is that interim order?
The interim order when is the interim order passed? Rakho, mark karo. And my lord, kindly see the remarks against my candidate. The candidate was not called for interview as he was not shortlisted due to not satisfying eligibility criteria decided by the respective screening committee. I don't understand this. Screening committee is, my lord, sitting for the purpose of fixing the eligibility criteria, sitting on the University Grants Commission. I say that on the basis of this, my lord, the entire appointment should be set aside and I should be called for interview. I have not been called only because you have put 57%. Where did you get it from? When the University Grants Commission is saying 55%?
September 18. Initial interim order was passed on 13.
Well, initial interim order was passed on 13 September 2018. And this order was passed in this appointment same day. So this is violation. Interim order was passed on the day 13 September.
4 noon.
My lord?
4 noon.
I don't know, my lord.
4 noon means
I submit you.
it will be around
Well,
10.
stretch the law as far as it can be in favor of the university.
10 a.m. At 10 a.m. But interim order, if it is passed on the same day, must be after 10 a.m. because the judicial hour starts from 10:30.
So if it is after 10, 4 noon means I don't know. 4 noon means before
10.
Before 12.
No, before
I think,
that,
I think 10.
before that, keep the picture of that court. Which Dr. Patre appeared. Madam Minister Sinha was insisting that I pass immediate interim order initially. Before that, he said that I am taking instructions. He took some time.
Retirement that your retirement will take effect from 4 noon means 10. 10 a.m. Next day.
Because it was the case was filed, madam.
Why this haste? I just asked this question to myself. Why this haste?
Dr. Patre appeared. He took.
Yeah, don't take the name of the council.
University.
That is the difficulty. He takes the name of the judges who were there. He takes the name of the lawyers who were there.
You don't do that. No, but I am on a much broader point. I submitted to your lordship. There was a hot haste in the matter of appointment. I say that you fix 57%, but without taking recourse to
These are all again the trial or like a civil case. When the writ application was served upon the university, because the interim order was passed on 13/9. That means service must have been affected prior to 13.
Yes. It was, my lord, affirmed on August 20.
Presumption.
If the records are for epidemic services there.
I am a lot looking at the whole there. Well, I don't want to unnecessarily make any allegation against the university.
So far as I am concerned,
They were not figuring.
I have the strongest of reservation against the nepotism, the favoritism.
Lordship.
If I find the single element of the nepotism and favoritism, I'm the last person to support them. It is only for that purpose I'm just trying to understand that what is happening.
But I am completely proceeding on the basis of the record and the university grants commission. 2 documents I am relying upon. Both documents have been disclosed with the university. One document says my score, my total academic record.
Point,
This is a short point, nothing else.
It's apparent. You got much higher marks than the person who has been appointed, but you are ruled out because they have taken a particular decision in the screening committee that the academic record means HS, undergraduate and postgraduate, averaging must be 57%, which you did not meet. Though you have all the criteria, you meet all the criteria.
And I am also questioning why this 57%? Why?
That cannot be. Then why? Then it will open. Then
no, I am saying that you can, of course, for the purpose of screening, you can fix a mark. But that should not be arbitrary. It can't be at your sweet will. It is not 60. It is not 55. It is not 50. 57%. Why?
Then I'm
সেটা তো অলরেডি ফুল
I'm good on you.
Can I hear him?
Yes, well, only thing is that
With, yes, with leave of your lordship, my lord. My lord had called me up, my lords. The appellant has mentioned the matter, my lord, without giving us any notice, my lord, without saying. My lord, lordship had called me, my lord.
Yes.
My lord.
He was saying that there are a lot of problems which he's facing. Then I said, at least last month we have called the matters, but nobody responded it.
My lord,
Uh,
in this matter, my lord, lordship will recollect, my lord, I'm being led by Mr. Mukherjee, my lord, Mr. Prowal Mukherjee. My lord, lordship, there is an appeal and counter appeal filed by the defendant, my lord, against the dismissal of the partition suit. My lord, we were the plaintiff, my lord, we filed and
now I asked because he was saying that I am unable to depend on my whatever.
My lord, there was no notice, my lord. I talked to Mr. Mukherjee also. He said that he didn't inform us anything, my lord. And my lord, their substitution applications are pending, my lord. Respondent, sub-respondent have also died.
That's it. And the litigant has come forward.
My lord,
and
my
this
lord.
issue.
My lord, sorry for the inconvenience, my lord.
We don't know
My lord.
then why he should consult you that what is the
My lord,
problem. If the substitution applications are there, these applications were called on for at least twice in the last month.
He affirmed the substitution on 23rd, my lord, here.
Then,
Last.
then why? And I was under the impression that it must be some writ petitions where the monetary release and all everything is there.
Lordship had referred a
He says,
judgment
I
also, my
don't
lord.
have any money to take care of my ailing whatever.
Nageshwar Majumdar and Sabita De's matter also, lordship referred that matter, my lord, to my other side.
So,
my lord, they are the appellant in
it was
that matter, my
taken
lord.
up. It is not that the matter was not taken up.
My lord.
So he is projecting as if
Yes.
because
My lord,
money is stuck up, so
27 respondents are there, my lord, and one after another respondents are dying, my lord, and we have to make a substitution, my lord. That's a difficulty, my lord.
Everybody is when they approach the court suffers
My lord,
the same problem.
If your lordship fixes on a day, my lord, we will be do that, my lord. We are always ready, my lord.
We are taking up the matter when it is called.
And I told him that whenever it was called, we were there. A lot previously, matter was taken up, and lordship had this.
It can be done.
Matter,
Then why you allow such a litigant to come bypassing you?
My lord, I'm extremely.
We will hear him personally.
My lord, I'm extremely sorry, my lord, but
we'll hear him personally.
We had no information, my lord. We had no information.
Let him argue his own case.
My lord.
Let him argue his own case. He says, I can't bear the expenditure of my client. I say, I can give a legal aid. Sir, we can give.
আমরা ছেড়ে দেব
না না আমি কি অন্য পারি নাকি
Then the legal aid we say that we can provide from the legal aid. No difficulty.
অনেক পদ্ধতি আছে যারা মারা গেছেন তারা তো পার্টি হবেন তারপরে তো মামলা হবে
ওটা সাবস্টিটিউশন হয়ে গেছে
সাবস্টিটিউশন হয়ে গেছে he has filed and he is saying he has affirmed he is saying that it has been done that is not the process how much things we can explain
So we'll have to take care of that.
আমার
Not the way
বললে
not
হবে
the
না
way
একটা
to do it.
প্রসেস আছে আইদার আপনি নিজে করুন নিজে দায়িত্ব নিন না
Take care of it.
করুন তাহলে
Don't
করবো
take
তো
care of
করা যাবে
বইগুলোতে প্রথমে কোন জায়গায় I was, Millard, addressing my lords, Millard, on the point of maintainability. It's a private school, yes. Millard, these are the compilation, Millard. It is just.
একটা রাশমি ম্যাটারিকে ওনাকে মিস্টার বাসুকে দিয়ে দিন রাশমি ম্যাটারিক জাজমেন্টটা বাসু সাহেবকে দিয়ে দিন
একটা রেশমি মেটালিকের কি জাজমেন্ট আছে হ্যাঁ রেশমি মেটালিক রেশমি মেটালিক
give the combined. No. Read that guy.
Reshri Metallics.
Justice Vikramji Singh. You have semi juniors.
This is on this point.
Supreme Court, paragraph 6 or 7, maybe 5. These are relevant.
Judgment.
Reshmi Metallics.
Reshmi Metallics.
Supreme Court.
देखिए
11 সেপ্টেম্বর 2013
विक्रमजीत सेन, जस्टिस विक्रमजीत सेन,
বিক্রমজিৎ সিং।
जस्टिस विक्रमजीत सेन। देखिए
এটা কিন্তু আমি ইন্ডিয়া কারণ এসএসসিটাও খুলছে বলে আমি এটা খুলিনি, হ্যাঁ প্যারাগ্রাফটা মিলবে না।
पैराग्राफ मिल बने ना
বার করো, খুলছে না।
ठीक
প্যারাগ্রাফ মিলবে না কথা না, হ্যাঁ
पैराग्राफ मिलते हैं
I think within 5, 6, 7 paragraph.
প্যারাগ্রাফটা মিলবে না।
मिलते हैं
Can you hand over to me the judgment you have opened?
the India Canon मिल और the yes
Judgment you have opened?
judgment tender matter में
Give it to me.
The-
I
the-
just
the-
wanted one paragraph to be read.
ঠিক আছে।
what
বুঝেছেন? 11 সেপ্টেম্বর 2013, 11 সেপ্টেম্বর 2013, Mrs. বিক্রমজিৎ সিং।
I was correct, paragraph 6. Yeah. Read it.
টাচ হয়ে গেছে।
Read yourself. What hospital? What hospital?
yes my lord paragraph 6 I have read yes
What you derive there?
now my lord without going into the lengthy argument my lord the stare decisis the court must my lord follow my lord but in this case my lord the St. Mary's School and my lord the other judgment my lord did not consider my lord the earlier 3 based judgments my lord which I wish to rely upon. Number one. Number two, my lord, I have, my lord, made my argument, my lord. If your lordship, my lord, allow me to. No. It is not a question of shutting up. If your lordship feels that, my lord, I have thought, my lord, that your lordship, my lord, on the last occasion, my lord, indicated your lordship's mind
the territorial jurisdiction, pecuniary jurisdiction, inherent lack of jurisdiction. Other two parts that can be, but the last one, it cannot be compromised. Now, my lord, the term inherent lack of jurisdiction, my lord, the authority of the High Court to decide the subject matter placed before it, if I say so, because your lordship was also minded to reveal your lordship's mind to that extent. Now, my lord, to that, on that score, my lord, I would humbly submit to your lordship, my lord, that if your lordship takes up a situation that the subject matter means, my lord, suppose if a tribunal, service tribunal, has decided an issue which was not within the ambit of it, within the ambit of the tribunal's jurisdiction, subject matter. So this is inherent lack of jurisdiction. It passes a decree for nullity of marriage, or my lord, at the instance, my lord, at the inception. Today, my lord, under no circumstances, subject to what my lord will say, that we can say that the High Court under Article 226 jurisdiction could not take up this matter and could not decide the issue on law. The High Court had the jurisdiction because I have, my lord, understood the Constitution, subject to what my lords will say, that there are express bar, rather the Constitution puts a clog on the Article 226 court in a way, my lord, to 323 AB in a matter. Directly, my lord, original jurisdiction cannot be. Your lordship house has taken the same view following.
Is the Constitution
Right? And my lord, possibly article,
any clock?
it's a barrier. Right. It is a,
There
it,
cannot be any clock
right.
on the exercise of power. And
But it is a bar. It is a bar. It is a bar. So, my lord,
that this can be exercised even against the authority, provided the authority comes within the purview of Article 12.
right.
Secondly, it says that it can definitely intervene when there is a public law element is involved.
Right.
And the authority is just discharging such duty. Definitely, it will come within the purview of Article 2.
Right.
But the St. Mary and the Army Territorial, or yes, this Army Welfare or whatever, this latter judgment, very recent judgment, they made a very fine distinction. They say that a school, unaided school discharging the public law function stands on a one footing. Then the subject matter relates to service conditions of a teacher vis-a-vis that unaided school. The moment it comes between the employee or a teacher or the school, then it comes within the private law, under the private realm of a private law. If it is under the realm of the private law, then the 226 is outside the purview. That cannot be exercised. This is what a fine distinction this is sought to be made. Unaided school are not subject to Article 226. No, it's a wrong notion that it cannot come, provided it all depends upon the subject dispute.
So, my lord, I was, my lord, I was thinking, my lord, I have prepared myself, my lord, to argue, my lord, first, my lord, that the inherent lack of jurisdiction, and my lord, then I will address, my lord, that public law, public function, my lord, public function, my lord, even then, my lord, what has fallen from my lord just now, my lord, if I take that route, my lord, then, my lord, I possibly cannot survive in this way. I will say, my lord, I will address this issue, my lord. First of all, my lord, I have to show that the subject matter, my lord, I thought that the term justiciability is a term, my lord, which denotes that the court is authorized to do the lease between the parties, my lord, within the periphery of law. Now, my lord, this term justiciability has been, my lord, subject to correction, divided into two parts. One is normative justiciability, and another is institutionalized justiciability. Institutionalized justiciability, my lord, it indicates that the court decides the issue by resorting to the legal principle. First of all, if I may say so, if I, my lord, go back to the first limb of submission, that Article 323, because your lordship in DA matters also said, while I filed an application under Order 1 Rule 10.2, addition of party, your lordship says you should have gone there. Since, my lord, the state had given consent, I was allowed to be added. Now, my lord, the another article subject to correction, Article 329, which says, my lord, that election petition is a bar. So, my lord, apart from these two, my lord, there is no other law, my lord, possibly, which, my lord, restricts the contour of, my lord, the 226.
Civil matter.
Civil, yes, yes. It is. No, yes, it did not come because this was
appeared.
right.
The landlord happened to be, say, unaided school. Then it will come under
No, I am, yeah, no.
226 if the school is not accepting the rent. 226 will be approached, compelling the school to accept the rent. The school is not providing any facilities or amenities, since the school, in fact, discharges the public function. So definitely the tenant will come against such a school and will compel the school to provide those facilities and amenities. I think
yes,
that would also be embraced within the rhythm of the
no, I am not saying so. I am saying, my lord, that the Judicial Review Court, my lord, possibly, my lord, since your lordship has said, my lord, I may be, that is my understanding, my lord, that the specific, today your lordship, on the last occasion, your lordship said that inherent lack of jurisdiction, that is what, my lord, troubling your lordship's judicial conscience. Now, my lord, inherent lack of jurisdiction, so far as my journey is concerned, my endeavor, my lord, that is the court's power or authority to decide the subject matter. Subject matter here, my lord, possibly means the dispute between the parties. Court said that I have the authority to take up the issue and to decide the issue in accordance with law, and ultimately, my lord, this court has come to a conclusion that this is not justiciable, it is not maintainable, because read does not lie. Number one. So, my lord, on this score, it is not the case that the forum from the day one, my lord, that was closed for the litigant. The court had decided the issue. Court had the jurisdiction to decide the subject matter.
Court is approached, point of jurisdiction is taken, the court decides the
Court, that is why
ultimately court held I have no jurisdiction.
No. Court had
facet of those
Millard, if I may, Millard, be allowed to say, subject to correction, Millard, that court had an authority, or court has an authority to decide the lease between these parties. But here, act number one. That is why court had come to a conclusion that the writ petition is not maintainable because I do not have any legal right in this matter. That is why if
no, you may have a
legal right, but the 226 is not a court will not.
Enforceability
is a bar. Is
dependent upon a remedial
so, Millard,
forum.
So,
what is the remedial forum?
Millard, the remedial forum, Millard, the RTI application has been responded to, Millard, that is yet to be constituted by the Anglo-Indian Regulation Code. Now, Millard, this Code 1993, Millard, this is a judgment of your Lordship's Court Division Bench, which says, Millard, it has a statutory force in a way and it can be implemented. Now, Millard, if I may pursue my Lord's judicial conscience by saying that the disciplinary procedure, the method that has been adopted, enumerated in the Anglo-Indian Code 1993, Regulation 24, Millard, it defines the contour of the relationship between the employer or employee, and the school is bound to follow that. The school is bound to follow that regulation because it is a listed school. Now, whether I can, Millard, pursue my Lord by saying that infraction of such rule by not following that rule while, Millard, initiating a proceeding and terminating the employees, Millard, without any taking recourse to such proceeding, Millard, that writ petition lies because it is not a case where, Millard, the entire the regulation can be waived, can be ignored, can be overlooked. The regulation says, Millard, what are the procedures that are applicable to this. The authority school had, Millard, admitted this. Now here, my lord, that is one of the judgments, my lord, I am relying upon. The first point, my lord, the court had the authority to decide the subject matter. Court had decided and court says that court will not. By reason of, my lord, the settled law, by taking the judgment, and, my lord, the self-imposed restriction. And also, my lord, the court says in a way that this is not a public function, public law domain. But in this case, my lord, I will show that the Anglo-Indian Code 1993, my lord, is binding. The school, my lord, is bound to follow this. Now, the school, it is not a case in the earlier writ petition in the appeal court until Supreme Court, my lord, between the same parties, same subject matter, my lord, that the school had followed this. The school said school had never raised the maintainability. School had never said that it is not obliged to follow this rule. And, my lord, on the contrary, the school, after, my lord, the long-lasting Curial combat, my lord, ended in Supreme Court. Ultimately, the school, my lord, followed the division bench order because we alleged, my lord, non-compliance. The Honorable Division Bench says, no, you can file a writ petition. That is why second writ petition was filed. Whether, my lord, I am entitled that this question of maintainability between the parties, my lord, it is, my lord, today, my lord, this maintainability point, my lord, is not available with them. Because many a times, my lord, your lordship said there are contrary decisions also, that even a wrong judgment binds the parties. On this code, the school has acted upon. The school, my lord, followed this because the Honorable Supreme Court, my lord, did not interfere with.
Once a wrong is,
My lord, that is the
not redressed or corrected, it will
no.
continue.
No, I will not say that it will. No, my lord, in all cases, not in all cases, not in all cases, my lord, but subject to correction, my lord. In these particular cases, my lord, in these particular cases, all issues were made available. Issues were never, my lord, cropped up. Issues were cropped up. The petitioner has, the respondent school, my lord, has never taken this point. Those were available to them. But the question is, my lord, the Honorable Division Bench was quite conscious of the fact, my lord, because all records were there. The Honorable Division Bench said, my lord, I have read for your lordships, my lord, on the last occasion, page 101, my lord, that any punishment, the school said, my lord, taken a stand, my lord, without going into that question, that dismissal and removal are different aspect. Now, my lord, my lord, today, whether I am, my lord, entitled to urge this point before your lordship by saying that inability to take a class for one day, whether it entails dismissal, it is such a misconduct because it, my lord, hurts, my lord, the conscience of the court, it is disproportionate. The court had found it. Now, my lord, accordingly, the court. Today, my lord, this journey, this argument, possibly cannot be made available. But even then, if your lordship says that the wrong judgment, but today, my lord, the coordinate bench had passed this. Whether this factual aspect is binding.
Actually, had it been on this court and the coordinate bench says that the writ petition is maintainable, at this point be taken into account and then decided by a coordinate bench in relation to a parties.
Same parties.
That the writ petition is maintainable, we could have appreciated.
But the writ petition was entertained.
Writ petition was entertained.
Writ petition was entertained.
Coordinate bench, where they did not raise the issue of the
maintainability.
Whether that would be construed to have abandoned the point of maintainability, and a subsequent coordinate bench is bound by that particular decision.
Because, my lord,
and cannot reopen this.
My lord,
if you can cite a judgment, no difficulty.
No,
I have not come across with any judgment of this kind.
No, I said, my lord,
No difficulty.
1994. Maintainability point has to be raised.
No, it's not helping. Because you can raise it at any point in time.
Now, my lord, the today, my lord,
Not helping him.
না 2022 যেটা হলো ওটা করনি
একই কথা একই বলেছে
Now, my lord, today he said, my lord, the judgment which I have referred, my lord, that has been today, my lord, I said, my lord, that the finding of fact, because it is a mis question of fact and law, Today, my lord, division bench judgment, my lord, if your lordship kindly takes pen to page 101, if I may be permitted to read for my lords, then, my lord, your lordship will be pleased to find the division bench, honorable division bench, has discussed the issue at length in a way. And, my lord, which, my lord, indicates that the endeavor of the division.
At that point of time, the St. Mary was there in vogue, or army was there in vogue? Or it was pre-stage of St. Mary and the army?
The show mentioning judgment is post St. Mary's.
St. Mary, post St. Mary is Justice Shane's judgment, Justice Shaw mentioned division bench.
Was it taken into account?
No.
St.
No, my lord, Justice Shane's judgment was, my lord, brought to the Honorable Supreme Court also. They've carried out appeal. Right? Yes. Now, my lord, they. Huh? My learned senior friend says that Justice Shane's judgment, my lord, that is not a post.
2019.
2019. But the question is, my lord, today, this point was made available.
No. One is when a judgment under Article 141 is there may be a earlier.
My lord, to that, my lord, I will show.
They are maintainable. They may not take point. Subsequently, when a judgment came,
Law is changed. Now, my lord, today
they are within their rights.
Three judge bench, my lord. My lord, in my compilation, my lord, this Reshmi metallics, my lord, I could not go through it, my lord, in its entirety.
No, not necessary. Only paragraph 6.
My lord, in
that
this,
a caution is given to the members of the bar.
Yes, that is the don't waste public time.
Don't create a menace into a judge's discretion of delivering a judgment.
Now, my lord, this is, my lord, paragraph, this is, my lord, to 2021, 7 SCC, page 535. 2021, 7 SCC, 535. Paragraph 109.
एकदम लास्ट दिए था मेरा 109.
Millard, I at the instance at the outset, Millard, on the last occasion, I referred to Millard Article 13, and this was discussed, and it says, Millard, the tenor of Article 13 clearly suggests that it was not enacted to paragraph of the
109.
Jigya Yadav, huh?
Paragraph
109. The tenor of Article 13 clearly suggests. Oh, sorry, Millard. 109. 2021, 7 SCC. Now, Millard, that it was not enacted to restate the obvious proposition that all salutary laws are laws in any legal system, for it requires no restatement that laws enacted by the legislature are laws. The underlying purpose of defining law under Article 13 is to encompass a practical administrative reality, and there can be laws other than ordinary salutary laws. It therefore takes within its sweep those matters, declaration in the form of bylaws in this case, as having the force of law, albeit not enacted by the legislature as such. For it defines law to include ordinances, orders, bylaws, rules, regulation, or notification issued made by the state. The precise meanings of these terms cannot be confined in the rigidity of the language, and the same is neither desirable nor required in the present case. Now, Millard, why I read this? Because, Millard, this Anglo-Indian Code 1993, Millard, Millard, it says that what are the procedures to be followed, Millard? This was issued by the state government, and
13 primarily or basically founded upon the continuity of a law enacted before adoption of the constitution by the people of this country. And therefore, it says that after this constitution is adopted, any law which is inconsistent therewith shall not be regarded as a valid piece of legislation so far as our country who is governed by the provision of the constitution.
Right.
The law and the law in force both have been defined in that article also.
My lord.
I think which has also been defined under Article 372 as well. If I correctly remember, my memory goes or does not betray me. Same way, but on a different notes. Then it says it encompasses or embraces the various aspects, which says not only the enactment or a law or a substantive act, but also the ordinances, the bylaws, the delegated legislations, the subordinate legislations. Everybody has been encircled or robbed within that. And then it says that you have to consider. So Article 13 stands on a different footing. If you make a law that is within the legislative domain of the state, the union, and the collective powers of both the union and the state. If I phrase it in this 7th schedule, those powers to make law is always there. There's no difficulty that you can't make the law.
No, I was.
This is how one has to consider that it should not offend any core value of Part 3.
It also sends a caution, my lord, to the state that it shall not make any laws.
72 is also where I think it talks about the adoption. Article 372. There also the laws and laws in force are.
It saves the operation of previous laws possibly.
No, this is Article 13. If you look at Article 13(1).
Article 13 also says, my lord,
Continuance in force of existing laws and their adaptation.
Correct.
saves the previous laws.
That's why I'm saying here also all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions, shall, to the extent of such inconsistency, be void.
Yes, and I was then, my lord, proceeding, the state shall not.
That's a caution to the state.
That is the future.
That's why it says that previous law, to the extent of inconsistency, void. Then say the state shall not make any law which would take away or abridges the right conferred under this part, I think part 3. And any law made in contravention to this clause shall, to the extent of contravention, be void.
My lord.
These are the two things which says. And then in this article, the context if required, then what is the law and what is the law?
Then, my lord, it went on, my lord. The honorable judges, my lord, have explained, my lord, the interpreted 109. Now, on this score, my lord, if I, in this context, if your lordship considers that 1993 regulation is a law.
Now the question is the law. Law means what?
Law means, my lord, here it says.
By law, this is by way of an ordinance, order, bylaws, by way of the rule, regulation, notification, customs.
And 111, the examination revolves around the expression having in the territory of India the force of law, irrespective of the packaging in which the said provision is formally couched. The text implies us to focus on the substance of the provision and not its form. Broadly speaking, law made by the state refers to a broadly speaking, law made by the state refers to a body of rules which shapes the rights and liabilities of person in a universal sense, as opposed to a private transaction between parties. Correct.
This is where one.
So this is yes. It lends an assistance, my lord, subject to correction. Now, my lord, if your lordship first, my lord, if I take a logical path, my lord, that if this is the, my lord, the understanding of the Honorable Supreme Court, which is binding under Article 141, then, my lord, in this context, whether the 1993 regulation, the notification can be considered as law. If it is law, then whether the school can avoid it. Next line, my lord, allow me to read. Such law has the ability to bind people, providing for all prominent aspects of their conduct as the subjects of law. Therefore, any rule, notification, order, bylaw issued, made by the state or instrumentality would have the force of law and bind all entities subjected to it and operates as a code of conduct to regulate their functioning. Yet, another crucial characteristics would be enforceability in a court of law. Needless to observe, we are not talking about binding codes or set of rules decided by the parties for themselves as they fall under the realm of contract. We are dealing with the rules which flow from instrumentality of the state during the performance of essential public functions. Now, my lord, this is, now, my lord, if the Anglo-Indian code, my lord, on the last occasion, your lordship has
Para 112 as well.
the CBSE, despite being packaged as a registered society,
Judgment.
yes, laid down the certain character is a public function. Thus,
Then come to this St. Mary's after.
yes, coming, my lord. A body is performing public function when it seeks to achieve some collective benefit for the public or a section of public is accepted by the public or that section has been authority to do so. Bodies therefore exercise public functions when they intervene to participate in social or economic affairs in the public interest. Now, my lord,
And this was taken into account in the St. Mary. If you come to St. Mary's judgment.
now, my lord, Saint Minister Barcode.
You have not.
The reverting to no.
Violation.
No, 115 my lord. CBSE is the central body for
St. Mary's in my.
central body for conducting examinations in the country. 115 my lord, 115.
I have read.
It is the only central body for conducting examination in the country created by a resolution of the central government. All the bodies constituted at various levels are working in the direction of just educational governance. Article 41 of the Constitution Council's directive is the source behind the basic functioning of the CBSE board, as it secures nothing but right to education. It is participating in educational affairs which form an.
This is your compilation.
It has an index.
No, it's. Oh yes, index is there. Yes.
Now, my lord, I was, my lord, reading 109 and 10 for the simple reason and 11 that, my lord, that in this context, whether the Anglo-Indian Regulation Code 1993 can be declared as law, if it is a law, then whether the school is, my lord, empowered, is under obligation, my lord, to follow this direction. If your lordship says that the one hand it is a law, then and
I have. Please correct me because I may be wrong. In Narayana,
No,
I have taken into account this Jigya Yadav's judgment.
yes.
I have taken into account in internal page 19 of the judgment and have distinguished the same on a particular thing.
My lord, in this, my lord, in those judgment, my lord, this particular regulation, which was framed by the state, my lord,
Was there because
no, the Anglo-Indian regulation.
in my judgment, I have not only quoted paragraph 105 of Jigya, I quoted 115 also.
Yes.
I quoted 120 also of the Jigya and 22 also of the Jigya.
No, I am, my lord, I again, my lord, at the cost of tiring repetition, subject to correction, my lord.
So those were taken into account. Binny's judgment was also taken into account by me at those days. And then
No,
please tell us that.
no, I said, my lord, this Anglo-Indian Regulation Code and its nature, this was never discussed, my lord, in either of the judgment.
Not in a,
No.
in an exactitude, but one can have.
No, my lord, I possibly, my lord, could not make myself clear. I said that if in the context of 109, if Anglo-Indian Regulation Code 1993 is a law, then, my lord, whether school is under obligation, the school has never said that I am not under obligation to follow this. The authority has, my lord, the law, my lord, my lord, otherwise, my lord, I will show a judgment of your lordship's code. Division, 2009, my lord, I will show a judgment to your lordship, my lord. 2009 SCC online, my lord, 1904. My lord, 2009 2010 1CHN 6760. 2010 1CHN 760. May I read for my lords? Moreover, the said regulation issued by the Governor of West Bengal has been framed to regulate the Anglo-Indian school and other schools, and it has been cast a duty thereunder to discharge amongst the recruitment and termination of teaching staff. Taking aforesaid aspect together, we hold that the writ petition is maintainable as against the school, as rightly held by the learned trial judge. Maintainability of a writ petition is one thing, and to enforce the justiciable right in the read petition is another thing, and it has to be examined whether the appellant has been able to make any justiciable cause before the learned trial judge or not. The allegation was that the order of termination was in violation of Regulation 23. To examine the aspect, one has to examine what was the status of the appellant at the time of termination, as the appellant was appointed as a probationary teacher for 1 year, and it will from the letter of appointment. Therefore, we appropriately quote the language of the letter of appointment. The quote has been quoted. Then, my lord, from the language of the letter of appointment, it is thus clear that appointment was made by the Board of Governors. The rules relating to the management of the school has not been brought before us, nor it was placed before the learned trial judge. Therefore, we do not know whether the principal have any authority to issue any letter of termination or not. The general principal rule of service jurisprudence is that appointing authority normally issues the letter of termination unless it otherwise provided. But before we discuss this matter, we have already observed the status of the appellant at time of termination has to be determined in the context of Regulation 21E of the said regulation. Factually, the letter of extension was issued on 2 days before the expiry 1 year probation. Regulation 21E, the said regulation provide as follows. Ordinarily, a teacher appointed against a permanent vacancy will be placed on probation such and such. Then, Miller, the termination. Ultimately, the teacher was reinstated. We declared that the order of termination was not lawful, as rightly held by the learned trial judge. So, Miller, I was, Miller, addressing your lordship, Miller. I was trying to impress upon your lordship by saying that even if, Miller, Reed does not lie, but the question is, Miller, the obligation, Miller, to follow the Anglo-Indian Code. Miller, if it is a law in terms of Article 13 and 109 of the Supreme Court judgment, Miller, whether I can argue before your lordship and urge and appeal to my lord's conscience that, Miller, this law has to be followed. And, Miller, if that is so, Miller, and termination and disciplinary proceeding when enumerated in Regulation 1993, Miller, it is a condition of service, Miller, in a way. One cannot, Miller, avoid subject. That is my little understanding.
Well, this was taken into consideration in army also.
Miller, army, Miller, I have not found that whether this particular code, Miller, this code was never. Miller, this code.
Just wait.
No.
When I say something.
No, I said, Miller, this particular.
When I say something.
No, which I'm sorry, Miller, I could not.
I have a question. In paragraph 16 of the army, you will find that it was further argued that the CBSE affiliation bylaws norms 3.5 category provides that the school in India must pay salaries and admissible allowances to the staff, not less than that the corresponding categories of the employees in the state government schools or as per skills, etc., prescribed by the government of India. And therefore, it was argued that once the CBSE affiliation bylaws creates an embargo, I mean the obligation, not an embargo, then anything which is done contrary to the same will be an act in violation of the statutory provision. This was repealed. It was repealed.
In this case, Miller, no, my question is, Miller, in this case, Miller, this judgment, Miller, division bench judgments, Miller,
that is what is troubling me, because I have also taken into account this CBSE, this Jigya.
Yes, your lordship has said this.
And I have taken a particular view. And it says that what are you arguing was also taken into account, this particular judgment, which is taken into account by the army, where the same argument was advanced regarding this CBSE's bylaws and the law, because bylaws is also a law within the meaning of Article 13. Law defines even bylaws included. Then we owe a duty to consider our relevant aspect to the matter. Although this aspect which we want to take notice of has not been highlighted by the respondent number 1, yet we must look into the same. We have referred to CBSE affiliation bylaws in an earlier part of our judgment. Appendix 4 of the affiliation bylaws is with respect to our minority institutions. Clause 6 of Appendix 4 is with respect to a disciplinary control over the staff in the minority educational institution. We take notice of the fact that Clause 6, the state has a regulatory power, which you are trying to portray, power to safeguard the interest of their employers and their service conditions, including the procedure for punishment to be imposed. For the sake of convenience at the cost of repetition, we quote Clause 6. Clause 6 says, while the management should exercise the disciplinary control over the staff, it must be ensured that they hold an inquiry and follow a fair procedure before punishment is given. With a view to preventing the possible misuse of the power by the management of the minority educational institutions, the state has a regulatory power to safeguard the interest of their employees and their service conditions, including the procedure for punishment to be imposed. It could be argued that as the state has a regulatory power to safeguard the interest of the employees serving with the minority institutions, any action or a decision which you are now arguing taken by such institution is amenable to a writ jurisdiction under Article 226. In the aforesaid context, we may only say that merely because the state government has a regulatory power, the same by itself would not confer any such status upon the institution, that is the school, nor put any obligation upon it which may be enforced through a issue of writs under Article 226 of the Constitution. In this regard, we may refer to and rely upon a decision of this court, the Supreme Court, in Federal Bank, while deciding whether a private bank that is regulated by a Banking Regulation Act 1949 discharges any public function. This court held thus. Then the Ramakrishna Mission's case was there. It says that in any view, a private company carrying on a banking business as a scheduled bank cannot be termed as an institution or a company carrying on any statutory or public duty. A private body or a person may be amenable to writ jurisdiction only where it may become necessary to compel such body or association to enforce any statutory obligations or such obligations of the public nature casting positive obligation upon it. We do not find such conditions are fulfilled in respect of a private company carrying on a commercial activities of banking. Merely regulatory provisions to ensure such activities carried on by a private body's work within a discipline do not confer any such status upon the company, nor put any such obligation upon it, which may be enforced through a issue of writ under Article 226 of the Constitution.
I'm extremely grateful.
This is what the court has said, that merely there are certain law regulating or touching upon a certain field. That does not mean that it can be enforced by virtue of a writ. Then it says, thus the contracts of a private nature would not subject to a writ jurisdiction merely by a fact that they are structured by a statutory provisions. The only exception to this principle arises in a situation where the contract of service is governed or regulated by a statutory provision. Hence, for instance, then K.K. Saksena's case was also taken into consideration, and then it was said that says that sum up that an application under Article 226 of the Constitution is maintainable against a person or a body discharging public duties or public functions. The public duty cast may be either statutory or otherwise. And where it is otherwise, the body or the person must be shown to owe that duty or obligation to the public involving the public law element. Similarly, for ascertaining the discharge of public function, it must be established that the body or the person was seeking to achieve the same for collective benefits of the public or a section of it, and the authority to do so must be accepted by the public. Even if it be assumed that an educational institution is imparting public duty, The act complained of must have a direct nexus with the discharge of public duty. It is indisputably a public law action which confers a right upon an aggrieved to invoke the extraordinary writ jurisdiction under Article 226 for a prerogative writ. Individual wrong or a breach of a natural contract, mutual contracts, without having any public element as its integral part, cannot be rectified through a writ petition under Article 226. Wherever the courts have intervened in their exercise of jurisdiction under Article 226, either the service conditions were regulated by a statutory provision or the employer had a status of the state within the expansive definition of Article 12, or it was found that the action complaint has a public law element. It must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its action becoming amenable to judicial review by the Constitutional Court, its employee would not have the right to invoke powers of the High Court conferred under Article 226 in respect of a matter relating to service where they are not governed or controlled by a statutory provision. An educational institution may perform myriad function touching various facets of public life and in the societal sphere, while such of those functions as would fall within the domain of public function or public duty be undisputedly open to challenge and scrutiny under Article 226 of the Constitution, that the action or a decision taken solely within the confines of an ordinary contract of service having no statutory force or a backing cannot be recognized as being amenable to challenge under Article. This is where it troubles me. Nothing.
No, Milord, I'm extremely grateful, but I again, Milord, at the cost of.
I have taken a pain of reading so
No, Milord, no, Milord, since Milord.
It pains, sorry.
No.
It troubles me. It may pain you.
No, Milord. Milord, only Milord, in this particular judgment, the Milord, service controlled service controlled by Milord the salutary provision.
This is what the court has
Right.
also
No,
said,
yes.
found that there was a statutory provision.
Here it is a statutory provision I am saying, Milord.
Then also the court says no.
Okay, but Milord, in this case, Milord, the division bench, in particularly this regulation came for consideration. They came up for consideration, and the court says, division bench, that this particular regulation is, Milord, if I have read,
It is applicable on
no,
the school.
hence it has been cast a duty they are under.
True. That is what I read.
No,
For
I
this
said-
reason I read. There is a regulatory provision, statutory provisions, where it says that the service of those employees or the teachers will not be varied.
Milord, with deepest humility and respect,
nor less than the state governments.
Milord,
Yet the court says that
no.
those are regulatory. But it does not come or
Milord,
cover.
Milord, two submissions, Milord, I have to make, Milord. First of all, regulate means, Milord, to direct. Number one. No.
Not always.
Number one.
Not
Number
always.
two, or prohibit.
Not private.
And second part, Milord, the particular.
To some extent is being controlled.
Milord, question is, Milord, that your lordship, but that Milord, your lordship has taken much pain while reading, Milord. But subject to correction, if I may have, Milord, missed the point. Your lordship never decided that whether the government had at all or the school had any obligation to decide the juror relationship. Your lordship never decide. If your lordship on the one hand said,
can a government appoint?
Question is, Milord, that the regulation,
Have the power to
Milord,
appoint.
Milord, subject to correction. No, Milord, subject to correction, Milord. If this regulation is, Milord, of no meaning, ultimately it, Milord, sends no significance, or Milord, it is of no consequence. then my lord, this obligation, my lord, this absolutely, my lord, that is
It is not of any consequences. It is not of any, the binding effect or something of
but
that.
this is
The
what it
question
says. It has been
is
cast
the
a duty.
choice of forum and the exercise of
No, my
power.
lord, in this case, my lord, the Anglo-Indian regulation, the court said division bench. This is particular regulation.
Statutory regulation.
But it says that it has been cast a duty to discharge amongst other termination of teaching staff. Cast a duty.
The why I read it.
Yes, my lord.
Distinction is sought.
My lord, this
that
was
the regulatory provisions, statutory provisions, where the school are obliged to do certain acts. This stands on a one independent footing. But the moment the employees come, vis-a-vis
this is also here, my lord, the employees regulated under the Anglo-Indian Act.
Division bench were not there before the St. Mary or the army. After the St. Mary or the army. Or if they did not take into account these two authoritative judgment of the Supreme Court, then in that event, we can't shut our eyes.
No, I am never asking my lord to. No, my lord.
No, I have to be very choosy about my expressions, the use of words, the juggleries of
My lord, I was trying to not request my learned friend apropos paragraph 6 of Rashmi Metal Leaks. But suppose Mrs. Bose sets up a boutique today and she employs an employee there. Will that But I don't have personal knowledge, but I only gathered information derived from records, which I believe to be true.
Okay. Reliable source.
Now, my lord, apropos a case of termination of an employee in the boutique, will it lie?
that entire process is wrong. If permission does not arise, it has to be scrapped.
Lord, they have also not challenged Lord, the proceeding.
It's not there.
Lord, they have, Lord, I say, Lord, they have also not challenged the Lord, recruitment process.
One of the matter, the prayer was only for participation. In that matter, it was held that we can't overlook the fact.
Lord, but
I think that was one of the judgment of Justice Pratap Kumar Ray. That we cannot overlook.
it was also not Lord, subject to kind sanction.
No, it was a case where only prayer was to permit him to appear in the interview. And later on, the other candidate who challenged the matter before the division bench, there was no prayer. The division bench says, I know there is no prayer. But we cannot overlook because it is a judgment in rem, not in personam. If it is in rem, every action has to go. This is what the sum and substance of the judgment.
But another judgment, Lord,
It has to go.
Lord, another judgment, I was also Lord, relying, Lord, which has been delivered by my Lord Justice Amit Talukdar, Lord. I'll give a copy to your Lordship's.
Prior or after?
But that
is
was
2008 and 2007.
Lord, this is Lord,
More particularly 2007 judgment.
the Justice Talukdar, Lord, delivered in 2011. And the another judgment also
Did this judgment
was not. But K. Visheshwara Rao was taken into consideration.
Whatever it has interpreted in a particular manner, then how can you?
And Lord, the other Bari Lord appeared in that matter, Lord, and if your Lordship would kindly take Lord one paragraph.
All Mr. Bari.
Lord, yes. So far, Lord, the education and this Lord appointment and Lord, the moment there is a Lord doubt, Lord, to clear that even they are going to pinch it. So Lord, here in this case, Lord, Lord, I'm specifically today, Lord, I'm about to Lord argue before your Lordship, Lord, since Lord, even that part, Lord, which has fallen from your Lordship, Lord, that so far the Lord scrapping of Lord every procedure, Lord, they are also Lord, my Lord Justice Talukdar has observed certain things, Lord. I need to bring to your Lordship.
To Justice Bhaskar Bhattacharya's judgment, that is a special bench judgment.
Lord, that was Lord.
It's a special bench judgment. Maybe a division bench, but special bench.
This was on reference, perhaps.
For reference, for answering the reference.
Lord,
Here, three judge bench.
So, Lord, your Lordship is looking at Lord since it has not been published. Now, Lord, by subject Lordship kind sanction, Lord, if I may be allowed to say so, Lord, since Lord, the right which was available, Lord, to the appellant was pursuant to Lord rules framed Lord under a particular act. Lord, they were not the person who were aggrieved. The person who were aggrieved or a person who is aggrieved, Lord, he approached the court because of the reason.
The sponsored candidate.
No, I was not sponsored candidate.
Oh,
they were
person aggrieved is a person who is the sponsored candidate.
Initially not, because they were the.
I mean in the appeal.
In the appeal. In the appeal, Lord, since Lord, they say that according to rules, Lord, the process of Lord, the notifying the Lord vacancy, then Lord sponsoring, and then Lord supplying the names Lord to the schools, and thereafter Lord the selection process. But Lord, where Lord that Honorable Supreme Court Lord in the K. Visheshwara Rao judgment Lord has said, Lord, there are two parts, subject Lordship kind sanction, Lord. One, Lord, is definitely Lord wide publication. Lord, another Lord is that the person who is aggrieved, and if he brings Lord the issue before the court, and then Lord the court decides the right and Lord secure Lord protection under Article 14 and Lord allows him to appear in the selection process. So Lord, selection process, it was the obligation of Lord the institution to Lord wide circulation. But if it is not done, and if I am the person aware about
what the judgment says, that it will vitiate the whole of the entire selection.
But in some cases, Lord, I've got another Supreme Court judgment which was relied on before the Honorable Single Judge, Lord, which says, Lord, that was the Honorable Apex Court, Lord, has stopped in that juncture that maybe it has not been widely circulated, but you cannot throw away a candidate who has not been sponsored from the. employment exchange.
No, that is what the judgment is taken care of. This is one thing. Please consider. It is one thing that in view of the Viseswara Rao's judgment, any candidate whose name was not was sponsored by this point of employment exchange has a right or can raise a grievance before the court for its participation. And the court cannot deny that participation because that's a right emanating under Article 14.
Obliged.
In the 16, particularly in
16.
the public employment.
16.
16. In the public employment, everybody must get an opportunity to participate. It is something different that what would happen to that recruitment process where there has been a complete, or I would say the brazen violation of the Viseswara Rao's mandate. The division bench, two division bench says that it is the judgment in rem by virtue of Article 141, not in personam, and therefore it vitiates the whole of the process. Justice Bhattacharya, I think Justice Bhaskar Bhattacharya holding the special bench also answered, it will vitiate. But the third question order of reference was that what would happen after the court says this? Will the court direct the authorities to reissue the process or reactivate the process according to the rule which was prevalent, or
the subsequent new rules came into play?
That is answered.
That is also
so category is that it vitiates according to these two division bench judgments.
Subject to your lordship, if I may be allowed to harp,
participation is one, and vitiating the entire process is different.
If I may be allowed to harp on relying on one Supreme Court judgment, Lord, which was relied on before the learned single judge. Lord, may I place the judgment, Lord? Dhananjay Malik.
Yes.
Lord, Dhananjay Malik and others, Lord, 2008, Lord, SCC 171.
No, it is not relied. No, it is only the Sanjit Kumar sheet. The division bench judgment?
Yes, Sanjit Kumar sheet.
And Rabindranath Mahata was relied?
Yes, Lord.
And
Sushi.
And one is the Pritilota Nanda.
Pritilota Nanda, Lord, I am also Lord going to rely, Lord, because they are also.
Apart from these three, there is no other judgment relied.
Lord, let me start with Lord Pritilota Nanda, Lord. That judgment was relied before the learned single judge.
No, you can rely any judgment to us. Which judgment you really heavily banking upon? You said?
Lord, yes, Lord, your lordship
give that 2008 judgment.
Lord, I'll come later, Lord. Your lordship would kindly see, Lord, first, Lord, the Pritilota Nanda, Lord. The Union of India, Lord, challenged, Lord, the proceedings before the Honorable Supreme Court, Lord, that went up because of the reason, Lord, the recruitment was done, Lord. Lord, a particular candidate was not sponsored, and thereafter, Lord, he was given appointment. The Honorable High Court, Lord, set aside the appointment, and thereafter, directed, Lord, to tribunal directed, Lord, to give appointment. The High Court set aside the order of tribunal, and then, Lord, challenging that the Lord, Union of India went. Lord, there, Lord, the Honorable Supreme Court, your lordship would kindly have a look, Lord. And there also, Lord, KBN Viseswara Rao was also relied on, and আমার কাছে স্যার তিনটেই কপি আছে আপনি তো আমাকে আপনি একটা কপি করে দিয়ে এসেছেন দুটো দিয়ে এসেছেন Lord, I'm relying on paragraph 20, 21, 22 and particularly, Lord, Paragraph 20, Lord,
How it is applicable?
Lord, because of
Yeah, I need not have to say. You are cited, we'll
it
consider.
is applicable because of the
Yes.
reason, Lord.
I have seen that.
Lord, your
I
lordship,
will dictate. Don't worry. Next judge. Next
Lord, the
judge.
another limb of submission subject lordship kind sanction, Lord, the judgments, Lord, which my learned friends are relying, Lord, on the date, Lord, when the right accrued to participate in the Lord selection process, Lord, the all other judgments, Lord, has a Lord prospective operations, Lord, that is, Lord,
Yes. All the judgments operate retrospectively unless expressly made to
say,
operate.
Lord, but Lord, the
Now,
issues,
next judgment, 2008. Next judgment, you say
Lord, yes,
2008.
another judgment, but I'm kindly allow me to place because of the reason, Lord, a person, because of the reason, Lord, at that point of time when, Lord, a right was.
Understood. Let me decide the point. What you are arguing against the settled proposition of law.
No, Lord,
Every judgment, if it comes in the midst of a the litigation, has its applicability. Only when the court expressly make it to the observe. Say in case of a arbitration, when this Bhatia International was there in the invoke, everybody was following the Bhatia International. Subsequently, the larger bench in Balco came and says that the Bhatia International is not a correct proposition of law, but expressly made that this judgment will operate from the day, because all the proceedings which has already been undertaken in terms of the Bhatia International will not be affected.
That's
the question was because it will operate retrospectively automatically and will affect the pending proceedings as well.
That's Lord saving clause and repeat clause, Lord, as
not saving. That's why the court has to make it express intention that it will operate from a particular.
That's Lord, coming from General Clauses Act.
No. General Clauses Act, Section 4 or 5 or 6 talks about something differently. Saves all the earlier one. Is a different matter.
But Lord, your lordship is restricting, Lord, since Lord, there is Lord, only one aspect that your lordship saying.
I'll tell you very frankly, when this 2005 amendment came in the Hindu Succession Act, where the provision relating to Section 23 was deleted, where the female heir was debarred from claiming or instituting a partition suit in respect of a joint property. This was lifted. Many cases were dismissed. The appeals were pending. Then this judgment came, and this was made to operate retrospectively. Judgment was considered. Now the right has been there. The suit is maintainable. Judgment was set aside, and the decision was taken. What are you talking? That it will relate back. It should be decided according to the old judgment because it was under the Tusi Rai's regime. It was all there. Only the sponsored candidate. No difficulty.
My contention is Lord, since Lord the.
No, I understand what you wanted to say. It's not acceptable.
Lord, I was beseeching your lordship not to, Lord, take, Lord, or proceed further, Lord, that since, Lord, it has not been widely published in the newspaper or widely circulated, my right does not go. Lord, that is what.
These two judgments are against you. Two continuous division bench judgments.
Lord, the judgment which today, Lord, my learned senior friend has referred.
These are the two judgments which he said that I have already cited. Is a Devendra Mondal and Gayanath Rajvanshi. Gayanath Rajvanshi is absolutely the same fact.
Lord, in the other Lord special bench judgment, Lord Rabindranath Mahato, Lord, where
It was taken into consideration, Rabindranath Mahato and Gyaram Rajvanshi. It was taken into consideration.
But Lord, the
and
other
then says no. Subsequent judgment in this Devendra, it has been taken into consideration. It has been taken into consideration in Devendra. Ratanlal.
আমি যা দেখলাম নীতিগত অন্য কথা
It says the full bench judgment being Rabindranath Mahata, as referred by the learned advocate for the appellant, there is no doubt has overruled the decision passed in Devasis Dotto Supra.
Yes.
But the ratio of the judgment was following KPN Visweswara Rao and Rajkumar versus Shakti Rao, reported in 1997, volume 9 SSC. The paragraph 26 of the report leads that in view of the matter, then Rabindranath Mahato was considered and then held no. Says that it is tuned with Visweswara Rao.
But indeed, Lord, that's the judgment of Lord Rabindranath Mahato. Rabindranath Mahato has said, Lord, specifically said, Your Lordship, Lord, on the last occasion, Your Lordship would kindly take Lord paragraph.
This is what I'm telling you. This is what Devendranath Mondal, the division bench says. After quoting Rabindranath Mahata, then they say, before the full bench, there was no argument advanced on the issue that if KPN Visweswara Rao, the apex court mandated the mode of declaring the vacancy by advertising in the newspaper, having wide publication, and also in the notice board of the employment exchange, so that all eligible candidates being in the category of non-sponsored may appear in the interview, satisfying the equal opportunity clause of
all
Article 14 of the Constitution. In full bench judgment, there was no issue whether a non-sponsored candidate suo moto or out of charity and or grace of the employer alone could be allowed to appear in the interview before the non-sponsored category from the non-sponsored. But there was question whether any non-sponsored candidate was eligible to appear in the interview or not. Then the full bench of this court in Rabindranath practically has followed the Visweswara Rao, which was a judgment in the field whereby a non-sponsored candidate may appear in the interview subject to the advertisement of the vacancy in the newspaper, and this issue that subject to the advertisement in the newspaper or wide publication neither was addressed nor argued and thereby was answered by the full court. Hence, Rabindranath Mahata in the instant case has no applicability herein, and it cannot be a binding precedent to us due to the law of the land under Article 141, as declared by KPN Visweswara Rao, read with Arun Kumar Nayak Supra, holding otherwise. Similarly, the judgment as relied upon by the division bench in the case of Gopal Sinha is distinguishable. Herein also no argument was advanced on a basic feature of the Constitution under Article 14 and 16(1), as well as the mandate and applicability of the Visweswara Rao, Keshwanand Bharti, Indra Sahane, Uma Devi, R.S. Garg. Furthermore, in that case, there is a distinguishing feature on factual matrix, namely the writ. The court in an earlier writ application allowed the appearance. Having regard to such, the said judgment has no applicability in the instant case, and then proceeded on this basis, and then said that on the careful reading of the said judgment, it appears that there was no argument advanced on the point whether non-sponsored candidate without an advertisement of the vacancy suo moto or by permission of the employer may appear in the interview. If so, whether the same hit the equality doctrine of Article 14 and 16. When in Visweswara Rao, the apex court by larger bench decision, a 3-judge bench held that there should be a public advertisement in the post, and subsequently in Arun Kumar Nayak, the apex court held that the public advertisement of the vacancy is mandatory. Following the above principles, it appears that all judgments are gone and it is a settled position, there is no conflict, and the entire process goes. So this was considered. If a division bench has interpreted the full bench decision in a particular manner, then the coordinate bench is bound to accept. Only exception is that if the coordinate bench thinks that I cannot agree with this, then it has to refer the matter to a larger bench. I mean, the Honorable Chief Justice to constitute a larger. We do not find any.
Not only one judgment, if I may be allowed, Lord Justice Talukdar Lord has held Lord that
without noticing these judgments.
Without noticing these judgments.
This is par incurium. If the earlier coordinate bench decision is not accepted, and if it runs counter to that, subsequent bench decisions cannot be rendered a good law.
In Sanjit Kumar, it has also not.
So it has to go. Not a good law.
Not a good law, what was available to the respondent. The respondent being aware, it's merely because of the reason that it was not published, subject to lordship kind sanction, the entire selection process may not be scrapped because of the reason, on that date, the subsequent rules of 2019 did not came into force. These proceedings were started in the year 2007. At that junction, 2005 rules was applicable. So, since it has fallen from your lordship and your lordship has expressed that entire proceedings in view of the judgment of the Honorable Supreme Court as well as the Honorable Special Bench, if your lordship strike down the entire selection process, subject to lordship kind sanction, one paragraph of my Lord Justice Talukdar's judgment, I'll read for your lordship. Your lordship would kindly take your lordship would kindly have a look. Admittedly, the rule came into force in 2009. Your lordship would kindly take. Your lordship would kindly take paragraph 23, 24, and 25 together. This is 2011 SCC Online, Calcutta 71.
No, your client, Sushil Kumar Biswas.
Seven 714.
It does not indicate which party.
I
think he must be there.
But it says in paragraph 4.
What? Oh. Yes. A different.
But why I am citing, if I may be allowed to draw a distinction between two. One, court-sponsored or court upon direction of the court, if somebody appears in an interview and as a whole, the institution has not published it. My endeavor is to that juncture. If the court finds and somebody approaches the court and court finds that yes, he has eligibility criteria and there is a violation of K. judgment and allows that particular individual to participate in this election process. This is one. And the another one is that at all, it was not published and a person comes and challenges the entire selection process.
Absolutely. You are correct.
I'm saying the entire selection process.
Correct.
But there
you
are
are correct.
two things.
That is answered by Justice Pratap Kumar Ray. That is what troubles us. I invited your attention.
On the last occasion,
troubles us.
On the last occasion, I took leave from your lordship, and thereafter, after a little research, I could answer and try to segregate two things.
What these two judgments, you could not make a distinction.
Two things that, as I said, one, the right accrues from the order of the court, and the other, as a whole, the entire selection process is before it.
This guy says that as a whole it will go.
I have really not applied my. If I could, if I may be given 5 minutes time to Your lordship has
read
your lordship has read, Lord, if I can bring out anything.
this the earlier judgment of
Lord, I was trying to argue that the courts
কোথায় গেল?
that if I may be allowed to stitch like this, Lord, that if person has approached the court, grants liberty
Yes,
to
Gyanat. In the paragraph 3, Gyanat is the same point was there. Challenging the judgment, the writ petition was dismissed. The appellant moved the writ petition praying the following relief. First relief was for that the writ in the nature of mandamus commanding the respondent number such and such, the secretary of the school, to allow the petitioner to appear before the selection committee prepared for appointment to the post of a peon of the state high school, along with the other candidates, is sponsored by this employment exchange as and when the interview will be held to the post of such and such. So he was not sponsored. This was the only prayer. And in that event, the court has gone there.
then the appeal is also dismissed because of the reason, Lord, he has not challenged the Lord the
So,
selection process.
on the analysis of the Vishweswara Rao, the case of Hargopal, the judgment passed in Arun Tiwari, reported in such as the apex court in the Arun Nayak has held. Therefore, the decision of this court in Arun Tiwari is based on the fact of this case, namely the time-bound scheme and exigencies of service. No law has been laid down therein, but in Vishweswara Rao, a three-judge bench has laid down the law, and that is still holding the field. Then the learned division bench held. Hence, it appears that the Vishweswara Rao is a judgment not in personam, but a judgment in rem. And the same was a judgment declaring the law under Article 141 of the Constitution of India, taking into account reasonableness and fairness doctrine, equality of opportunity in employment in terms of Article 14 of the Constitution. From the judgment of Vishweswara Rao, it appears that an individual non-sponsored candidate got no right to appear suo motu and or by decision of the managing committee or employer concerned, allowing any individual non-sponsored candidate to appear in the interview as per their sweet will, unless the right of a non-sponsored candidate for appearance in the interview matures on the contingencies of the advertisement of the concerned vacancies in the newspaper and or employment exchange notification having a wide publication and on media, radio, such as such. As a corollary thereof, since an individual non-sponsored candidate got no right to appear in the interview simpliciter in absence of the aforesaid contingencies and other media, the High Court also sitting in the jurisdiction cannot allow the appearance of an individual until and unless there is an advertisement of the particular post inviting the names of the general candidates by publishing the same in a state widely newspaper. Then it says, in view of the above, with having regard to Vishweswara Rao, we are of the opinion that the prayer as made in the writ petition was not a fit prayer for being allowed, directing the appearance only in the interview. Admittedly, the post was not advertised in the local newspaper, inviting the names of the other candidates identically placed like a writ petitioner. And then it declares that
the single judge may not correctly dismiss the writ appeal. Last question to myself, Lord, if I may be, Lord, here he approached the court and the prayer was refused. But in my case, Lord, I was just beseeching your lordship.
This is what it says that it can't, but ultimately it struck down the whole.
But if it is, Lord, I am on a different subject, Lordship, Lord, I am repeatedly pursuing because of the reason, Lord, if a right is accrued by the order of the court, Lord, I was not initially allowed to participate in the selection process. Lord, it says, Lord, when the court has, Lord, there is this decision, Lord, says about when the writ court, Lord, dismiss the writ application, saying this, that you do not have a right to participate because of the reason there is a Honorable Supreme Court has directed, these are the things. But in my case, it is contrary. The court allows me in the juncture when I challenge the rules. Lord, it is not a simplicity that I was prayed before the court.
Anything more?
These are, Lord, this is the last endeavor from my side, Lord, that that the rule was challenged. The rule was challenged, and the challenge of the rule.
That the learned single judge has recorded.
Yes, that's the reason, Lord. I say that I do not fall within the category. The right accrued, Lord, pursuant to the order passed by this honorable court.
Yeah.
And since there's a stay, Lord, the right continued. Lord, these are my submissions, Lord. I have given, Lord, since, Lord, your Lordship has referred, Lord, the special bench judgment, Lord, I'm not citing the other two judgments, Lord, which has only taken care of, Lord, what would be the circumstances when the court, Lord, directed to appear in the interview.
Let us see what can be done.
To my Lord. This is another judgment, Lord, I'm relying, which is in the same queue, but Lord, but the court passed an order directing him to appear. Lord, the court had stopped, Lord, and court has taken into consideration that since his candidature cannot be thrown out. Lord, it is his challenge.
It's already there with us.
Lord, Sanjit Kumar Sheth, Lord.
You cannot say that your candidature can be thrown out.
But it is his challenge. It is not my challenge. Lord, that's the reason what I'm saying. He has challenged my participation. I have not said that the entire selection process is because I have challenged the rules.
Yes. What the state has to say, nothing.
Due to this appeal, Miller 2013 post is still vacant. Due to this application order, Miller panel.
If you dispose of the appeal, at least you will have some say on that. রেখে দাও পরশুদিন, হ্যাঁ পরশুদিন ফর জাজমেন্ট রেখে দাও কোর্টেই। কোর্টেই আছে, এখন তো সময় নেই বলে এটা করছি না। Anyhow, next.
Not obliged, Lord. Since on the first day your Lordship has
listed for judgment on Wednesday.
Since your Lordship has expressed the Lordship view on the first day, Lord, I was little apt.
What is just call the names.
Five.
I'm for the respondent number 1.
Can it be finished within 15 minutes?
And my learned friend, senior friend will complete them. I'm led by Mr. Mukherjee, Procedural Mukherjee.
But it will take 15-20 minutes.
You will be arguing or anybody? Yes, your senior leader is there.
My leader is there, Lord. He is on leg, Lord. He will be coming. He is just coming. May I start, Lord?
He's not coming.
He's coming, Lord.
No.
Huh?
Held up somewhere else.
Yes. Judgment was easy.
Can I keep it on Wednesday first?
Yes, Lord.
After I dictate that judgment, it will.
My Lord, instead of Wednesday, can be Thursday. Because not
Civil matter, we will civil matters on Wednesday.
Because Wednesday.
Can be.
Huh?
Oh, Mr. Mitra is coming, pardon.
It will
As well.
be burden on his client.
Wednesday,
Yes, Wednesday, first. After this judgment is delivered, it has been complete. Yes, yes, adjourned. Next Wednesday.
Oh, certainly.
First item.
এই কালকে applications করে দাও, we will take up those applications first. আর আমাকে না জিজ্ঞেস করে এইভাবে তুমি রাখো না, একটা ম্যাটার শুধু হিয়ারিং এর জন্য রাখো, বাকি অ্যাপ্লিকেশনস গুলো রাখো, আদারওয়াইজ অ্যাপ্লিকেশনস হাত দেওয়া যাচ্ছে না। ঠিক তো? আর এই ফাইলটা পাঠিয়ে দিও। আর যেটা আছে কি ডিকটেশন দিলাম, ওটা তো বুধবার দিন জাজমেন্ট করবে, টাইপ করবে, আর কি ডিকটেশন ফাইলটা পাঠিয়ে দিও। So can we start application from tomorrow? Application. Tomorrow I'll take up the application first, and thereafter if the order 41, then we'll take up the order 41. ওইভাবে দিয়ে দিও। After the application, order 41 will be taken. Whatever. আর যেটা মেনশন হয়েছে সামান্য নয়, এত বাঞ্চ দিচ্ছে, ওটা কেন লিস্টে আসছে না কেন? রিকুইজিশন 48 আওয়ার্স এর মধ্যে আছে, তুমি আমাকে দেখিয়ে দাও কোন রিকুইজিশনে আর কেন আসেনি। If more than 48 hours, then tell me. দাও যে 48 ঘন্টার মধ্যে এলো না পাই।
বেশি তুমি ডেট রেখেছো এগুলো, তাহলে আমরা কি করবো? ঠিক আছে, শান্তি ওটা পাঠিয়ে দাও তো 15 তারিখ।
দাদা ফার্স্টে অ্যাপ্লিকেশন তারপর
সিরিয়ালি তুমি আমার অর্ডার বুকটা,
হ্যাঁ আমি দেখে দিচ্ছি।
অর্ডার বুকটা দিয়ে দাও, ওটা পাঠিয়ে দাও।